of reservations with reference to the twin constitutional test of racial differentiation and objects sought to be achieved. This is the logic used by the Supreme Court in order to justify 10% EBC reservations. And one more important consequence of this judgment is that court rejected tying of substantive equality to a fixed category of backwardness. Fixing of backwardness to caste consciousness. That is somewhat untied as a result of this judgment. And also, Dr. Ashwini Kumar is of the opinion that what the parliament thinks must also be given respect by the judiciary. He uses this logic. He says, I quote, the majority decision affirms that in a parliamentary democracy, policy choices representing the harmonizing of conflicting interests through pragmatic adjustments is essentially a legislative function that ought not to be overridden by judicial fiats unless plainly offensive to the engagement. It addresses the disquiet among the economically disadvantaged sections, it being excluded so far from orbit of states' empowering policies, validating thereby the Constitution's stabilizing function through the redressal of remedial injustices. Constitution is not static, it is dynamic. The judgments given by the Supreme Court also forms part of the constitutional law. Some part of the Constitution is bound by the constitutional traditions. There are gray areas in the Constitution, as you know. Say, for example, whom to invite to form the government in case there is hung assembly. It is not expressly stated in the Constitution, but it is governed by the constitutional conventions. Here, there is an evolution of Indian constitutional law taking place. We must watch it. But he also makes a caution. It is necessary to ensure that reverse discrimination is not stretched to a point where it eats up the rule of equality. Now that ceiling of 50% is relaxed. So the ruling party may have challenge because there may be clamoring from more influential sections of the society that they also want a share in this pie of reservation cake. We should not be very liberal, but be conscious in order to not extend it too far. The focus of whole society must be in extending the size of the roti or cake which is available, focus on development in rather than focusing and fighting upon which part of the share must be given to which section of the people. Say, for example, we are debating with regard to legalities of reservation policy, etc. But this is limited to government jobs, especially with regard to job reservations. But over a period of time, private jobs are more in number and government jobs are lesser and lesser in number. So from impact point of view, its limitation is getting diminished. Sir, how much more time I have? Sorry. How many minutes I can take, sir? Okay. I wanted to quote what Faizan Mustafa is saying on this judgment, what a professor from Delhi University is saying on this. I'm using this 2-3 minutes to quote what Vice Chancellor of National Law School of India University, Bangalore, is saying. He says that it reshapes affirmative action as anti-poverty policy. This judgment of the court. He also uses a term like caste-based strikes down over a period of time. It has the potential to reduce caste consciousness in affirmative policy. Reservations in India has historically focused on group disadvantages. EWS reservations ostensibly emphasizes individual economic status untethered from social group identity. In case of EWS, the unit is individual. The unit is not caste group or social group. He also draws attention to evolution of American constitutional law taking place. There is one organization by name Student for Fair Admissions in US. They filed some 2 cases in the Supreme Court. The core challenge in both the cases is whether race-conscious affirmative action in higher education on grounds of diversity is constitutionally permissible or not. Hearing is almost complete. Those judgments are also awaited. The judgment of the Supreme Court in EWA case in Indian scenario and the upcoming judgment of the American Supreme Court have got same political considerations. Before early 90s, reservations was only to SC and BCs. VP Singh, because of his political necessities, implemented long forgotten Mandal report and thereby 27% reservations came. There was self-immolations by students at that point of time. At least I'm happy that there is no large scale opposition to the extension of reservation policy here. How we all must see this issue of reservations as educated Indian citizens and as people with legal background, we all know our fundamental duties. I draw your kind attention to Article 51A(e) to promote harmony and the spirit of common brotherhood. It is the fundamental duty of every citizen of India. Also, to strive towards excellence in all fields of individual and collective activity so that the nation would constantly rise to higher levels of endeavor and achievement. Actually, I wanted to quote a complete letter of Pandit Jawaharlal Nehru, which he wrote to all chief ministers in India as to why he is opposed to the policy of reservations. It is also noteworthy that in those days, Sarojini Naidu, being a leading woman politician, opposed reservations on gender basis. Do we see such politicians today? It is a point to think over. Thank you all very much. Thank you.
Thank you, Mr. Srihari, for your views. I invite Jesse Chandru to.
Friends, good evening to all of you. Before you discuss a proposition on Constitution, you must have 2 parameters. The first is, it is not what is written in the Constitution, it is what the judges say. Number 1. Number 2, Justice Krishna Iyer once said, there may be one Supreme Court building, within that there are 34 Supreme Courts. Therefore, what is today certain proposition may not be the same proposition after some time. In fact, what it is very common in US Supreme Court, they call it as a number game, 5:4, 4:5. You saw how the abortion judgment Roe was weighed after 50 years reversed by the very same Supreme Court. And therefore, when I talk about 103rd Amendment and also the Mandal, actually the correct topic for today will be Mandal versus Kamandal. That would have been much more, it sends the point. Now, we are only doing post-mortem. You take 103rd Amendment and the EWS quota. It is given by 3:2. Suppose I was in the bench, it could have been 3:2 the other way around also. It's as simple as that. Why? You must know, before a judgment is rendered, you see the composition and then go into the background of judges, what is called as the, in corporate law, due diligence test. You have one judge, Parthiwala. I'm not going into names, I'm only saying in an example. He was a judge in Gujarat High Court. Number 4 in seniority is being promoted as a Supreme Court judge, superseding several people, including Akhil Qureshi. Now, when he was sitting in Supreme Court, in Gujarat High Court, there was one matter vaguely connected with the reservation. Now it has become fashion for judges to make all kinds of off-the-cuff remarks, not enriching the law, but more enriching the TV stations, breaking news. So you give some statement. But in this particular case, Pardiwala wrote that the most destructive thing in this country in the last 70 years is the reservation. How long this will go? When you are sitting as a judge, you also express your opinion very clearly. You go to the higher court, we don't expect you to change your stand. You will be the same person. And therefore, this 3:2 need not deter us from doing this postmortem. I also want to bring it to your notice. I was able to compare two parallel incidents, 1990 and 2022. These two incidents. One was Mandal, second was EWS quota. In what way both are connected? Both are related to reservation. One was admittedly OBC, the second was EWS. Both are reservation only. Now, Mandal, when the Mandal Commission, it was not any constitutional amendment because the VP Singh government did not think it required any constitutional amendment. Under Article 15(4)(a) and 16(4)(a), you can make an executive order which can take the place of a law. In fact, one of the arguments in Indira Sahni's case was that you cannot have an executive order, but that was rejected. When Mandal was announced, not by Congress party, not by BJP party, but VP Singh, who started his own party, it was announced. Unlike this kind of a classroom discussion, the matter was taken to the streets. In fact, Indian Express wrote an editorial, take to the streets. Can you believe All India newspaper writes an editorial, take to the streets, because they were very sure that Mandal Commission will be accepted by the court. And it was heard by a bench. In fact, I had an opportunity of appearing in that case. I was appearing for the UP government. Matter went on for a long time, but not waiting for the outcome of the case. There were street riots. In fact, in Delhi, one youth committed self-immolation. So it became emotional. It is not merely in fact, when it comes to every constitutional question, you must understand it is also a political question. Constitution itself is a political document. Therefore, when you take a stand, you also take a political stand, not like a lawyer. There are no constitutional pundits to say I am only a constitutional man. It's not like that at all. Secondly, when the written words are there and there are judges to interpret, under Article 141 it becomes the law of the country. It is also the mindset of the judges. That is why I said 3:2 could be the other way around also. Now the two did not disagree with the three. The two had a minor reservation. Altogether it's a judgment of 5. Now, how is that Mandal is different from this? If you kindly watch the Mandal argument, also the emotional outburst outside, the argument that was put forth was there can only be merit and reservation disqualifies merit. This is one. Meritorian principle. Secondly, that there is no power to bring in OBC. SC, STs can be there, there is already there, but OBC there is no provision for reservation. This is the second argument. Third argument was that you cannot bring in a reservation which can go beyond the what is called the Lakshman Rekha of 50%. If you make more than 50%, then it disqualifies, it creates imbalance. Therefore, Article 14 requires reservation will be less than the majority and not overtake the majority. This is one of the arguments, and number of arguments went on. By the time the party, the group the forces which opposed Mandal, the law took over and the Supreme Court held that Mandal reservation is valid, but two riders were put. First rider was that you can't have people continue to enjoy the benefit. Therefore, we should bring in a creamy layer. The same community should not enjoy the benefit again and again. Therefore, in order to broad base, you should have a creamy layer. The second was that the majority, it can't exceed 50%. These are the two parameters. Otherwise, OBCs are entitled for perpetuation. The debate before Mandal, that's most important. In this country, in the last 100 years, from 1920 to 2022, the last 100 years, this same debate comes in a different form. The Madras government, about the Madras presidency government, had a reservation of its own in 1921, what is called as the communal GO. The communal GO was a broad principle because the British, after the Chelmsford reforms, allowed Indians to participate in the local bodies. There were a broad-based public employment started coming, and therefore a complaint was made that all the Brahmins have coveted all the posts. We have not even a small entry. So the British thought we will have a communal distribution of all the posts. They have no qualms. There is no constitution. For them to rule this country is more important, and therefore they were able to bring in certain workable solution. The solution was Brahmins, non-Brahmins, Indian Christians, Muslims, and scheduled castes. Each will have a quota of 14 posts will be reserved among these 6 categories of people. It will go on a turn. Even the municipal chairman post, even the mayoral post has to be done by a communal rotation. For them, the grievance of the large majority of the people is more important than a constitutional standpoint. I know in Madras, till 1970, the mayor post was going by rotation. Upper caste, backward class, then minorities is going on. So this was some kind of a distribution, purely based on caste and religion. It worked for several years until 1950, when the constitution came. People are mentioning 15, 16. Constitution, if you see deeply, in 2 places is mentioned the word caste. In 3 places is mentioned the word class. In 6 places, the word scheduled caste is mentioned. Now, scheduled caste is defined under the constitution itself. Scheduled caste means a caste found in the schedule notified by the presidential list. Not the president, but the parliament only makes a list. And now, 6 places scheduled caste with a definition. Caste and class not defined. Now, how do you decide whether reservation can be done for caste or class? So, when the constitution came, this communal GO, which was also extended to educational institution, was challenged in Madras High Court. You will be very surprised. The person who challenged, the petitioner, one Champakam Dorarajan, you must have read in the constitution. Champakam Dorarajan was not a candidate for any course. She never applied for medical course. Like Indira Sani, she was not applicant to any course. She said, because of this, I may be edged out. It was an anticipation. Similarly, Champakam Dorarajan was not an applicant to any course in Tamil Nadu, but she said, I am aspiring for a medical seat. If this communal GO comes, I will not get it. Actually, there is a seat for Brahmins, they won one seat. But she said, I will be edged out. Merit should be the criteria. So the ultimate argument against the reservation was merit. What is merit, we will go into later. But then the person who appeared for her is Sir Alladi Krishnamaiyer, who was a member of the drafting committee of the constitution. He appeared as a lawyer. He felt that great injustice. Therefore, the Madras High Court simply said, caste has got no place. Therefore, this does not pass the muster. Matter taken to Supreme Court. Supreme Court also upheld the Madras High Court judgment. Matter did not come. The argument was, there is Article 46, there is Article 340. the Supreme Court said the only meant for public employment, not for educational institution. The argument was 46 and 340 also talks about general sense. We don't need to go because you can read all those judgments. I'm only saying as an example, the argument of caste-based reservation was rejected, but the argument that merit is a criteria was not gone into at all. Argument that was outside. Now, matter did not stop there. There was agitation in Tamil Nadu. At that time, it was Madras State. People who were used to the reservation, people who enjoyed and saw the fruit of the reservation, they did not accept this judgment. They took to the streets, and Pandit Jawaharlal Nehru made a first constitutional amendment. So, as a student of Constitution, you must understand, it is not the court, it was the people's movement which brought the first amendment, and thereby 15(4)(a) was introduced as an enabling clause, as an exception to 14, that you can make a reservation as a form of an affirmative action. Now, affirmative action for whom? Socially and educationally backward. It is not social backwardness. It's also not educational backwardness. It's a combination of the two. SEBC means there must be two criteria. In fact, in Mandal, the argument was it's all caste-based reservation. But then the Mandal Commission report said that though we took into account primarily caste, we have evolved a 24-point index, 12 index for the social backwardness, 12 index for educational backwardness. If any one of the community gets a majority under the two indices, a community becomes also a class, socially, educationally backward class. Because consistently, including in Vasant Kumar case, Supreme Court said caste cannot be the only criteria, but a caste can be an indicator to become a class, provided there are data. So the idea of data for any particular caste to be included in the list was brought in by various court judgments. Now, Mandal passed the test because it analyzed social and educational backwardness, and therefore it passed the test. So OBCs got reservation, SC/STs got reservation, so it all became a vertical reservation. What about the ceiling? Many state governments do not follow Supreme Court judgment. So they had, for example, in Tamil Nadu, we have 69% reservation, and that act reserving seats in public employment and education institution has also been included in the 9th schedule of the Constitution. It's by an amendment. Now, Supreme Court said, you may include it, but we have a power to decide whether the inclusion is right or wrong. You know what is 9th schedule? In the colloquial sense, it's called laundry bag. If I put some clothes, you can't open the bag. It's only the OBs can open. Now, Supreme Court said that we will go into the question whether the inclusion is right or wrong. Now, that matter is pending. But what is most important is most of these reservation issues have been gone into answer. Now, in all these cases, including Indira Sani's case, the Supreme Court said caste cannot be an indicator, only a class. Now, altogether, now there has also been further movement saying you don't have a promotion, so Constitution is amended, and you don't have reservation in higher educational institution, again Constitution is amended. All these amendments have been upheld. Now, there is no quarrel at all. But what is important is when 103 amendment was introduced, what is the basis of that amendment? They knew very well, unless it is socially and educationally backward, you can't bring education. Now, therefore, they say under the very same 15 and 16, notwithstanding, non-obstante clause is brought in. It's a very cruel way of drafting. A reservation is provided for SEBC. In the same article, you want to bring a subclass. Saying notwithstanding means you are not only bringing a new amendment, you are also rewriting the entire constitutional history. You are now first time saying socially, educationally backward is not the issue. Economically weaker section. Now, where is the class? Where is the caste? Now, if you analyze this 103rd amendment, 10%. In every judgment in the last 70 years, Supreme Court asked for data. how do you say that this 10% is arrived at? There are no data. In fact, if you, second criteria, that it will apply only to non-reserved section. The sections which are also so far receiving, they are not eligible for 103. They like to have their own compartment. So they made it a compartment. Now, what is this compartment? Economically weaker section, of whom either two non-reserved section. Who are the either two non-reserved section? Not a OBC, not a SC, not a ST. But it should be, to plain language, it is an upper caste reservation. All along, people have been saying there can't be a caste reservation. Now the government is able to bring in a caste reservation. What is class and what is caste? Now we see class taking over caste. What is the criteria? Why should a person who is a scheduled caste, who also comes within the economic weakness, why he can't apply? No, you are already having a reservation. Does it mean you are now bringing a new category of reservation of economically weaker? So even the two judges who disagreed, who gave a dissent note, they said, how can you have exclusion of these people because they are also economically weaker? They have no answer at all. So they have dissented. Justice Ravindra Bhatt and Chief Justice Zalavi, they have dissented. They said it clearly violates Article 14 because you can't have exclusion of these people. Otherwise, you are having a upper caste reservation. There is no data, and now you bring in totally caste, not class. The class is quantified by saying if you have a 8 lakh annual income. That's all right. Why that same criteria is not there for OBC? Nobody knows all these things. Therefore, when you, as a student of constitutional law, if you see the history of the various reservation cases, the argument that it was against merit was rejected. The argument it was an affirmative action was accepted. The argument that it should be a class and not caste has been accepted. Now you find all these three things have been thrown out by 103rd Amendment. People thought Supreme Court may look into the issue, but then we have 3:2. But in my opinion, not as a student of law, but also a student of politics, I feel this is a vote bank politics. And secondly, there is no explanation. If Indira Sani case talks about 50%, how is that this plus 10 becomes 60%? How is it valid? Are you not rewriting Indira Sani? Now there is no clear answer. People are trying to say something more. For in this context, I will only appeal to you because when you talk about EWS constitution, I have also written, it is a constitutional fraud on this country. You may ask the question, they have amended the constitution. Amendment of the constitution can be done several times. That is not the issue. In fact, Mrs. Gandhi, when she brought an election, she brought an amendment that the election of president, vice president, prime minister can never be challenged. That's also a constitutional amendment. Will you not strike it down, saying this is violative of Article 14? But their argument was, people in high places, if you could keep on challenging from Somal court, there will be destability. That can't be an answer at all. Today, the present constitution bench did not answer how 60% is valid and what happened to the larger bench judgment in Indira Sani. This present judgment did not consider the question, where is the class? Now, if you are belonging to Brahmin or some caste Hindu, you are automatically coming. Mark is not the criteria. Therefore, people who are votaries of meritorian principle, they are the one who are beneficiaries. Now, coming back to my original submission, that in 1990, when Mandal was there was so much agitation. Agitation doesn't take place on spontaneous basis. It was motivated. It was the ABVP. It was the BJP student wing which agitated. And today everybody is keeping quiet. Right from the amendment till now, nobody is grieving. Because the people who were originally giving their lives, giving their entire energy to oppose a reservation, are now keeping quiet because their mouths are shut. Because you are also getting 10%. Now the entire argument on reservation is no longer an argument. In fact, in 1990, there was no agitation in South India, primarily in North India. So some of us went to some of the North Indian universities. I went to IIM Ahmedabad. The poster, They didn't put Chandru. They said Mandal. It was some bad word. Mandal again. That's a topic. We went to several universities. We found so many hostile climate. Today, no hostility. Does it mean they have appeased everybody? Can a constitutional scheme be work only to appeasement? Should they not have a constitutional principle? Now that constitutional principle is lacking in the 103rd Amendment. I feel that this judgment should be revised. There is some review applications are there, it's been heard. Whether court agrees or not an issue, because there are several judgments have been reversed, like Nas Foundation. One judge said go to parliament. Then another judge said no need to go to parliament, it's unconstitutional. There are several things. In state of Rajasthan, dismissal of a government cannot be a justiciable reason. Now in Bombay case, you can always go to the court and review. Therefore, every judgment of the court, every constitutional amendment is an issue concerning the larger public, larger people, and therefore there could be change, a change of thinking. And in our country, the decisions are rendered on smaller benches, 2 bench, 3 bench, 5 bench. Last month in Bihar, they had a OBC reservation for local bodies that was struck down. On what ground? Data lacking. After the constitutional amendment under 16(4)(b) and 16(4)(a), 3 state governments made reservation in promotion. The classic case was Chhattisgarh government. They appointed a committee of a judge to find out whether they are adequately represented or not. The committee said they are represented, they are not been represented. So the government issued an order struck down by the court saying data lacking. You don't have a scientific data. Secondly, the Supreme Court in all these cases said it's an enabling provision. Nobody can go to court asking for a mandamus to enforce the order. Enabling provision, data, concrete data should be there. Now all these cliches we have been going through for the last 70 years. Suddenly all this has disappeared. I remember arguing for railway workers case. One of the argument was because of the reservation number of railway accident. Justice Krishna asked the pertinent question, does it mean reservation-free employment means accident-free railways? He asked the question. Do you mean to say we'll have no accident if reservation is stopped? Therefore, people ask all kinds of perverted questions, which we are not here to answer. The fundamental question is that this country, when it evolved a constitution, it also had certain basis for an affirmative action. For an affirmative action, you must justify, because it is violating Article 14. Now, what is the justification they had for the EWS quota? On practical terms, I don't want to argue on practical result, but I must tell you, if you see the latest banking recruitment, first comes BC, next comes SC/ST, third comes EWS. Then where is the merit? The cutoff mark that is fixed for State Bank of India, it comes to 14% for EWS quota. Now, therefore, you have given a go-by to this argument. Therefore, when they opposed Mandal, it was a political motive. When they brought in 103, is again the same politics which originally opposed. And when they can compromise their principle, we cannot compromise the basic constitutional morality, and I will call it as a constitutional fraud committed upon this country, and I'm sure Supreme Court should take a different view. Thank you.
So my role is summing up, very poor in summing up things. So I don't know what to sum up. At least the Professor Satish Deshpande's presentation, at least it has some academic quality, at least I could follow and I could really say something. But the other two from the legal practitioner, probably they are just, trying to find some kind of a, whether law we should understand this way or that way. So I'll just very briefly, Professor Satish Deshpande is trying to say that, if at all, if you want to address the economic weaker section situation or the poor among the upper caste. So reservation should not be the instrument. So reservation is just to address caste discrimination and historical injustice. So let us not use the reservation idea for that. So that is his major objection. And also he spoke about 4 models which were, there in practice in India. But all models had its own, they have their own problems. But it looks like the third and fourth model looks like very problematic. And the first model also, but for different political reason. But in the present context, these last 2 models are creating major issues. That is basically his central concern, is that we should not use reservation for addressing the poor among the upper caste. So he also says that EWS reservation is just for the upper caste. It's upper caste reservation, nothing but an upper caste reservation. So the people who spoke always against reservation, now they also claim reservation now. They also come under reservation category. Whether stigma will come at that point of time, we have to wait and see. Okay. So, and then Mr. Srihari's presentation is basically that, the larger society, Indian nation, should address this in a different way. And we all should take a responsibility to uplift the marginalized categories. And he is completely against reservation in various forms. And also he supports reservation only for the upper caste, and he does not find any major issues with EWS reservation. That is his stand. Huh? You are okay. Sorry, that's what I said. No, I understood probably wrongly. Sorry, you can correct me. And the last one is Justice Chandru. I think he said the EWS is actually a constitutional fraud, and almost used a very strong kind of a language. Probably, maybe I think in his view that I think what they are doing is a constitutional fraud. It's against the Constitution. It's against any kind of a constitutional morality or constitutional values. What they have done is so, and he is quoting various articles and how they are contradicting each other. So that is what I wanted to say, because we are already running late. So I just open it for question and answer. So, and we have mics here, and please come forward. Just you should specify the speaker and ask. Yeah. Just switch on the mic.
Yeah, it's on. It's on. Can everyone hear me? So, first of all, my question is with respect to a very particular statement you made in your speech. And of course, like whatever quotation you gave, different people may find it not related to a certain factor, but I find not coincidental with the fact that all people belong to the upper castes. And with respect to one statement that you make is poverty is caste neutral. And while I can give like many quotations from different judges, say that, okay, caste in itself forms middle class because of the nature of the Indian society in itself. I will quote to you a very recent Oxfam report 2022, which says that, and friends were discussing that yesterday. It very particularly, and its factual claim and factual reality that they bring forward, is for every 1 rupee that a upcast man earns, an SC/ST man earns only 55 paise. How is it then you claim that poverty
you quoted some reports saying that poverty is more prevalent among Dalit section of the society. Yeah, Mary. Caste was an ugly truth of India's yesterday. Should it also continue to be truth of today and tomorrow is in our hands. We should be forward looking and hope for a day when caste consciousness, caste-based discrimination will no longer be a reality. That report may be right or wrong. I have not gone through it. I have not studied the subject so in depth. But there are certain international reports while following which we must follow with a pinch of salt. Say, for example, we know the situation of the countries whose place is much above India in hunger index. They are now clamoring for wheat flour. And sometimes, especially with regard to international reports, there may be agenda driving force. Because of the reservation, some divisiveness among the society, caste consciousness among the society is being perpetuated. But we have to get rid of it over a period of time. I look forward for a time when those people who have got the benefit of society because of being already uplifted will say that we will no longer need these crutches. We will be among general category. I have patience to wait for that day.
Yeah. I also want to give a reply to. Yes. The reservation is not eternal. Constitution itself provides for, unless they are adequately represented, there is a test there in the Constitution. That is why the court says you must have data. Whether they are adequately represented, they are not. Therefore, there is a constitutional check on continuing the reservation. Secondly, the caste consciousness, it has been there from Mandal days, Manu days. Therefore, it's not something not through the constitution caste came. Caste is there everywhere. We are now trying to eradicate caste in different methods, but then that's not possible at all. Caste becomes one of the indicator. If you say the scheduled castes have been redeemed, they are not treated differently. They are not untouchables anymore. I don't think anybody can challenge. Only last week in Tamil Nadu, the water tank in which they are drinking water, it was fixed with human excretia. Now, how is that this is happening today? You can't say it's a personal fight. Then, if the entire SC/ST report, which is placed before the parliament, has got hundreds and hundreds of incidents of several atrocities against them, that's why there is a separate act. Now, nobody can say that if the reservation is not there, caste will disappear. If anybody can say that, I can understand. But on the other hand, it is now on the increase. In fact, recently, last week in the Tirunandapuram, there is a film institute in the name of K.R. Narayanan, former President of India. The film institute has got a director, and Shashi Tharoor is an MP from that area. Shashi Tharoor, also in the consultative committee of the institute, the students and the staff were on strike. Now, one of the argument, the demand was there is a lot of communalism within the institute. That's different. Then Shashi Tharoor said, I have dropped my caste name. This is what he said. But the agitation did not stop. Finally, the director has resigned. Now, suppose somebody says, I have dropped my name, the Nair word from my, does it caste disappear? Is it not in there? If you scratch, you will find out how much casteism is there, how much disability is there. Therefore, let us not wish away that reservation is the only issue for casteism. In fact, only because of the casteism, reservation is brought in as an affirmative action.
I am adding something more. Justice sir observed that caste consciousness has been prevalent in Indian society. judge or professor is judge lifelong. I'm a bit doubtful about that observation. Why? Because was it that prevalent in ancient days? I'm not very sure. Say, for example, the writer of Ramayana, Valmiki Maharshi, is from Boya caste. The mother of writer of Mahabharata is from Besta community. Lord Sri Krishna, who is adored as God, is from Yadava community, who may be among OBC category at present. Among Saptarshis, I don't think any of them were from Brahmin community. Also, it is noteworthy that during British era, communities used to give representation to the government saying that we want to be left out of this scheduled category list. But now, in post-independent era, we see clamoring for tag of backward, more backward, and most backward. Is it the direction which Indian society must go? We must ponder over. Thank you.
This quotation is from Dr. Ambedkar himself. It was Ambedkar who said that the Ramayana was written by Valmiki and Vyasa, who's a scheduled caste, he has written the Mahabharata. The Indian people didn't have anybody to write the constitution those days. They sent me to write the constitution. He has written like that. But he didn't stop with that. He said it's only a tokenism. Ultimately, I was born as a Hindu. I will not die as a Hindu.
Hello.
But it is also noteworthy that he chosen to not to convert himself to other religions. Also, there was lot of offers to him that if you are converting to this particular religion, we are going to give you these kind of benefits. He did not yield, and he opted to choose a religion which is an offshoot from Indian subcontinent. And I submit that Dr. Ambedkar must be regarded not just as leader of Dalit community, but as foremost leader of whole of Indian society.
So please circulate the mic. Yeah, over. Yeah, please.
Good evening. I'm Shrudila from the fifth year. My question is to Justice Chandru, sir. So there were many questions on how it would impact the basic structure, but I specifically on the point raised about it being violative of Article 15 and discriminatory. So I just wanted to understand your opinions on the implications of this and how you see this affecting the basic structure in Article 14 in the long run.
In fact, the two judges who wrote minority, they say it's between hitting Article 14. Because within a class, you cannot make a further class because only equals can be treated as equally. Unequals have to be treated unequally. You find that EWS is unequal. So you are creating a class. Within that class, you are excluding the other people from that reservation. They say it's a violation of Article 14. I need not say the judgment itself, two judges have said it's violation.
Thank you, sir.
Hi, my name is Bhavya, and my question is directed towards Professor Satish Deshpande. This is more of a clarification rather than a question that would fall in the court of law or constitution per se, because you chose to deliver on social theory more. So my question to you is, can enhanced forces of economic disadvantage expose individuals to discrimination, which may not be one based on caste, but one that definitely erodes human existence and requires constitutional accommodation? How exactly does the neutralizing take place if we see the judgment as one widening the ambit of the reservation to both disadvantage and discrimination? What is the desiderata which mandates legal policy to not address disadvantage as against discrimination in social theory, as per your opinion?
point is not whether you wish to address disadvantage or not. The point is whether you use a particular method like reservation. And in my opinion, reservation is a very strong measure because it is violative of Article 14, about which we have been talking. And therefore, it should be used only in the most extreme cases for which there is justification. So the justification for doing it in the case of the scheduled castes, scheduled tribes, and also for OBCs is that caste identities outlive economic status. Economic status may change of a person or even of a group over time. And if discrimination is based on that status, you would logically expect it to change. And unlike that, the specificity of caste discrimination is precisely that it is impervious to economic status. Within the group of millionaires, a Dalit millionaire will be discriminated against. Within the group of IAS officers, and so on. I would appreciate it if applause did not happen as part of rational debate, right? We are not trying to get the most popular view. We are trying to get at the best view that we can as a collectivity. So I just want to make that request. We all have our views. Yes, I understand that, and we feel happy when our views are. So just to continue, that's my point. My point is that you would expect economic discrimination to fade with when I get better off economically, I would expect that discrimination to fall off. But my discrimination against me and the converse, the advantages, particularly I should be speaking of that, the advantages that I have as a person of the upper caste do not cease if my economic status lowers. That too we must keep in mind, you see. Hence, caste discrimination as being a fit case for the judicious, careful violation of Article 14.
I just had a follow-up to that. Perhaps my question was a bit technical with the regard, wherein I wanted an answer about we keeping caste for discrimination, perhaps broadening the bracket of discrimination to other possibilities that the court might be exploring. How would social theory answer that question with regard to some disadvantages?
Yes.
Is the categorical division between disadvantage discrimination so
yes.
malleable? What are your views?
Yes. The area that is most relevant to your question is currently referred to as intersectionality. It currently happens to be very sort of an in subject. So there's a lot happening on that. It has a particular history and so on. In the interest of keeping my answer short, I'll say that we are still in the formative stages of theory on intersectionality being shaped. And it is my own personal opinion that the views on intersectionality that we have received so far are too strongly shaped by its origins. And we need, when we choose to invoke that term in contexts outside of that, we need to now rethink that concept and think about how it might apply in different cases. My suspicion is that if you want an honest and good theory of intersectionality, you will end up with very large typologies that generalizations will be very hard to make. So that we will need to speak in terms of emerging cross-sectional identity positions. So for example, a poor upper caste is one position. A rich lower caste person is another position. Then if you bring in another axis, you bring in gender. What I'm trying to say is that as you bring in more axes and as you consider more, instead of coming up with any general principles, we will come up with a multiplicity of points that need consideration in their own right. And I don't think this will be an incoherent collection of millions of positions, but it will be a much larger set than we are used to thinking of currently. That's my very short take on what social theory has to offer. And I hope I have managed to attract you that we are not entirely useless.
Right. Thank you, Professor.
Just pass it down. Backside, yeah.
Hello, this is Rashika from the third year. My question is directed to Professor Satish Deshpande, sir. So first of all, thank you for the 20 minutes. I really enjoyed what you spoke. We had the pleasure of, you were mentioned in our constitutional law class last semester, and we were told that scholars like you and Yogendra Yadav tell us that it's time to look beyond reservation and like you redesign affirmative action. And you in your what you spoke today also spoke about, you also spoke about targeted scholarships today. So sir, what is it today that the targeted scholarships that we have right now are lacking, and like what can you just elaborate on your idea of targeted scholarships?
Thank you for that. It's very flattering that, sociologists are read by people who make a real difference like lawyers. I wish to say straight off that my position on that has altered somewhat. I think we were being, at least I should speak for myself, not for my co-author. I think that we were being perhaps too naive and too optimistic to think that we could form, in fact, this is related to the previous question. The mistake that was made there was precisely to think that bringing in intersectionality will allow us still to make general statements, or will allow us to create new class categories or new groupings that will be few and easy to manage. The short view is that I agree with everything that is there in that article, except today I think that logic should be intra-group. So we should apply further dimensions within groups and therefore prioritize the urgency of access or the deservingness of access based on multiple axes, but within groups, not across groups. So it is not possible to compare a poor upper caste person with a rich lower caste person, for example, because I think there are problems involved in that, in equating them in some way or considering them as part of a larger, of a class on which the same operation can be performed. So I think we need to treat them as unique positions. That's my position today compared to that article.
Hello, sir. My name is Praseem, and my question is to Satish sir only, and it to what Bhavya Bhaiya has just said, that when we talk about reservation, that it is a upper class. So I think that, and you also added that class is temporary while caste is permanent. So in this discussion, what I feel is that we are undermining the discriminations that poverty brings with itself. Firstly. Secondly, I think this is the best part of the entire judgment, that initially framers of the constitution envisioned that reservation will end after 10 years, but it is indefinitely. I think that, can be ended, the social parity could be established.
No, by all means, this is the sort of space where we should be asking questions of all kinds, right? And that's why I was also saying that it should not be about who gets the most applause and things like that. What you're asking is a very serious question. It requires us to think to think carefully. You're saying that isn't it true that there was a similar question earlier as well? Doesn't poverty also lead to discrimination? My answer really is that yes, it does. But what this judgment is trying to say is that the discrimination, if there is, assuming right now that there is, that the discrimination suffered due to economic reasons differs across castes. Which, if you are creating a class based on economic discrimination, is, I feel, contrary to logic. So I would have nothing to say against the EWS if the exclusion category that the groups receiving reservation already need to be excluded from this, if that was not there. So then we are introducing essentially a horizontal category that applies to the unreserved category as a whole, and lets in anybody, including the upper castes, who fit that economic criterion. That to me would be logical, and I would personally have no problem with that. My problem is that this is being introduced, and what I probably did not make clear, why this seems to be leading us back towards the communal geo that Justice Chandru also spoke. On the one hand, the communal geo, by having developed a political formula for distributing resources among the major groups in society, might seem to be democratic compared to what happens now. The big problem with the communal geo is that there is no unreserved category. To me, the unreserved category is the category of hope for our society. If we want to move beyond caste in a genuine sense, that is what we have to believe in, that the unreserved category is going to save us eventually as it changes its. That is why I'm very upset and sad that what otherwise have been a progressive decision has brought caste back into the unreserved category and taken away our future from us. Because this is moving towards a situation, as already being predicted, more groups will ask. And if the political, it doesn't matter which government is in power. If the political electoral calculations are in favor, they will be granted. Now that the 50% ceiling is gone. And we will move towards the communal geo sort of situation. But what is as you undermine the unreserved category more and more, hope for the future of a beyond caste society recedes further and further. So we then have those eternal categories where we are constantly distributing things. Finally, I disagree. I mean, I know that Dr. Kannan had the unenviable job of trying to summarize things that he was listening to as we go. And we all know your lecture notes will tell you, right, what it is like to try and summarize someone, right? I disagree that the major reason for reservation today is historical discrimination. I think it is discrimination in the present. And as a rhetorical device, when it's asked, how long will reservation continue for? My favorite answer is, let 1 month pass where there is no atrocity anywhere in India, just 1 month. And I will support the withdrawal of all reservations.
Yes, we'll take 2 more questions.
My question is for Honorable Mr. Justice Chandru. So you mentioned the 50%. Yes. Justice Chandru.
That this 50% cap is now, keeping aside that argument, if we assume that this 50% cap is in fact invalid,
How does Justice Chandru explain that the poster child of reservation, which is the state of Tamil Nadu, has 70% reservation, 69% reservation? So isn't this a matter of convenience rather than a matter of principle?
Anticipating this issue, there was a petition filed that you should have a larger bench review Indira Sawhney's case. But this bench said we are not going to go to a larger bench, we will decide. Justice Ravindra Bhatt raised the issue. If 50% is the law, how is that we can take this 10% along with the other reserved communities? Now they have now answered 10 is valid. Now where does this 10 will come? The other, Karnataka and Tamil Nadu, is under challenge. Now that will go to a larger bench. They may decide whether 69% is right or wrong. They may decide. Now there is always a danger. If you say 50% cap and you accommodate 10%, then there will be BCs and SCs will lose some reservation. There is a fear. Even when Mandal came, the SC, STs were opposed Mandal, not all of them, some section, saying there's going to be danger. If you expand the kitty, there is always a danger for my quota. Now, therefore, in my personal opinion, there can never be any ceiling fixed on this. Number one. Number two, if it is affirmative action, what is the theoretical justification to say it shall not exceed 50? Nobody knows this. Now the other question is, when Constitution talks about when the other communities are adequately represented, means it is for the state government to gather detail and then work for it. Now Supreme Court has struck down the last 3 cases. On the ground, this data is lacking. This is one issue. Now, even in the SC/ST case, if you see 340, it should be efficiency in the administration. Even if you appoint a scheduled caste, it should not impede the efficiency. This is the understanding. Now, if you see the EWS quota, there is that condition is not there. Does it mean a SC/ST should be efficient, whereas an upper caste need not be efficient? This is something which is very logic. Therefore, this debate continues. There is no answer at all for any questions. That is lacking for yes. 340 is lacking.
Good evening, sir. So my question is addressed to Professor Deshpande. Sir, I wanted to know, since you referred to the specificity of reservation for scheduled caste and scheduled tribe communities and the later extension of this scheme to the socially and educationally backward castes with a creamy layer category introduced. Since members of the SEBCs do possess greater social mobility, for example, they're not subject to the practice of untouchability, and in many cases they are landed rural communities who are sometimes involved in conflict with members of the scheduled caste. So I wanted to learn from a sociological perspective, do you believe that reservation was the right way to go to address the backwardness of the SEBCs?
I was personally, in my personal opinion, I thought a one-size-fits-all quota approach to the OBC question was wrong. But as you know, laws are always complicated compromises between various kinds of winners, political winners and political losers. There are compromises that are worked out. And in that kind of a scenario, that is understandable. But once we recognize that these are invented categories and include very disparate elements, this is in fact a problem with reservation, the implementation of reservation policy for all groups today. Every single caste group has deep economic differentiation by region, differentiation by community, wherever that community is relevant and so on. And we are not quite sure how to deal with these differences. The political logic demands that what are considered as electoral constituencies should be kept whole and not splintered. And on the other hand, ground realities show that these groups are differentiated. In the social sciences, we cannot but take notice of these internal differentiations. In the political world, the existence of these differentiations doesn't necessarily lead to the same conclusions. So today, providing the same formula for large or a single formula for large groups is in logical terms questionable. But everything that is logically unsound need not necessarily be politically unsound. So we also need to think of what is politically feasible, and also in terms of whether different kinds of ways of dealing with this, what are their possible, ramifications, what kind of. So in short, the OBC category is a very, very complicated category, and it's only political expedience that has led to one formula being applied to that entire group. But it's a very tough challenge to devise something that will be both social scientifically better and politically acceptable.
Hello. This one is directed to Satish Garu. Am I audible like this?
Sir, regarding disadvantaging of by poverty, that can lead to discrimination. So you've said that up till a point, like discrimination has a historical background in caste-based system. So to face that, we have reservations. But basically, to the best possible ways, as said, to defend discrimination are reservations, one of the ways. So due to poverty also, though it's not historical, it's not that long it is. If suppose there is a worker, a cleaner, in any other sex of society, you see that person as a son of a cleaner or daughter of a cleaner, and they will be discriminated until they achieve that, until they have their achievements till that extent. So throughout their life, they will be seen as such, and they will be discriminated up to an extent. So at least in the educational aspects or in the employment aspects, I do think they need to have some sort of a reservation. What do you say about it?
Yeah, this is the question that keeps coming up again and again, and that's what I'm saying. That is what we need to look at. That is, what is reservation? Reservation is legally mandated representation, right? So if we are taking the group logic, then the group that we are talking about, for simplicity's sake, let's say upper castes, are neither as a group, neither educationally backward, nor socially backward, nor are they underrepresented in either higher education, in education or in government jobs, right? So for a group like this, you're trying to carve out within it some justification for reservation. Now, I'm saying this way of going about things is forcing the issue. The economic problem of poor upper castes needs to be addressed with economic solutions. And if you limit it to economic solutions, you can make it caste specific. But if you make it reservation, you must make it caste neutral, because otherwise, why isn't somebody else from some other caste who belongs to the same economic class? How can we say that the discrimination they suffer because of being poor is different from the discrimination that is suffered by XYZ other caste? That's my problem. It's an inconsistency, right? So if you use the method that is best for social exclusion, then don't limit it by in any way. But if you use methods that are economic, you may, if you wish, limit it by group. That's my position.
Sir, and I had one open-ended question.
No. We have speech and others. Yeah, please, quick. Yes, sir, please.
So my question is targeted at social topic, because everyone said that disadvantage and discrimination are distinct concepts. So my question is that, is there any method for existing in social organization to measure what extent advantage can reduce or qualify discrimination. And if they calculate how can we remedy that through policy and law? Because reservations are limited as we have through our experience. So I wanted your opinion.
No, this is a valid issue, and many people have been, struggling with this issue. But as I responded earlier as well, I've also been involved with sort of these kinds of things. But I believe that the large caste groupings in the Indian context form a context which is compelling in itself, and that therefore using the same formula across such locations, precisely what you're saying, it is difficult, sociologically indefensible to say that if I draw up a scale on caste terms and I draw up a scale on economic terms, let's assume for a moment that these are valid scales. We have somehow solved all the problems, right? So it's very difficult to say that if you're 2 points higher on the class scale, then it's okay for you to be 2 points lower on the caste scale. It's impossible to say that right now because it's not a arithmetic scale. The difference between Dalit and non-Dalit is not the same as the difference between the OBC and the upper caste. And the difference between all these castes and Muslims today is not the same as, and so on, you see. So that's the problem with society. It's messy, it's complicated, and there are no simple answers.
Last, yeah, please.
My professor is Professor Deshpande. So you mentioned in your speech that how, reservation is a separate, distinct remedy to undo historical injustices. While it
I didn't say historical.
basically justice is past injustices the lower class.
Continuing.
So at the same time, you also mentioned that had it been the case where, EWS reservation is applicable across all sections and along on reserved and unreserved categories, you are fine with it. But don't you think the moment we bring in OBC reservation, at that point of time only we very, conflated, or to say we polluted the very sacred or distinct idea of reservation. And if we also apply EWS reservation across all sections, it will further dilute the very idea of reservation.
Yes, thank you. This is a valid question again. See, you're keeping on demonstrating how complex society is. So I'm trying to reap some, kind of reflected glory that we are the poor souls who study this kind of stuff. No, you're precisely right that this is the kind of thing that happens. But how do you quantify it, or how do you capture it in a way that is firstly, intellectually defensible in terms of the conceptual tools we have and the empirical methodologies we have for measuring such things? And secondly, and much more difficult, how do you concoct a political formula that will allow us to give space to our academic sort of sophistication and yet work out a politically workable formula? That's really the challenge. And as I said, the OBC was the right moment for us to break up the idea of. But please do not forget that in our society, the OBCs also suffer discrimination. The only form of caste discrimination is not untouchability, right? And especially when it comes to jobs and education, that is where discrimination works very well. The simple, overwhelming idea of untouchability has dominated our thinking. But caste discrimination is a very micro-graded sort of spectrum. And to similarly have a graded micro spectrum of responses is a huge challenge. And we are infants in the face of that challenge. We're trying as a society, and I like to think that we will get better at this. But yes. I mean, that goes and there are historical accidents about particular political formations, particular ideological orientations. Everyone will have its problems, but some problems are different from others and so on. And in the end, it depends on historical luck. What is our luck as a collective people as to what is in store for us in working out a modus vivendi that will leave most of us alive and not fighting each other all the time.
Okay, so we have reached the conclusion part of it. So I request our colleague to say a vote of thanks, and also students decided to screen JBeam film today after this, and probably they will tell you the time, so they will screen. They are planning to screen today. They have asked for permission and I wrote to register. I think it will be granted. They will be screening the film.
All good things have to come to an end, and then hope the dialogue will continue. Because the question is complex, measurement is more complex, solutions are equally complex. As on behalf of our center, and maybe from other centers also, we'll keep these lively debates on. May not be at a starry level, but at another micro level we keep talking about. One point to be noted is that for the past 40 odd years, the idea of distributive justice is almost not spoken in India. Please do think about this whole idea called distributive justice. It is there in the Constitution. It's our motto. As we fail badly on that, we will search for lesser better alternatives. I call lesser better alternatives like reservations. They are lesser better alternatives. The best alternative is seriously thinking about distributive justice, the politics of distributive justice, the language and action related to distributive justice has to come back. With that note, I thank all the panelists and especially my colleagues, Manohar and Kannan. They put all their might to make this becoming a success. Myself, I played a little role in it. Thanks for all the volunteers silently who kept working for this, from designing the posters and then all that. Our IT department, which with very, very little glitch made this to go live stream. I'm happy because when I kept it on Facebook, I was bombarded with questions whether it will be seen across and all that. So I'm happy, and then I'm also happy that my old friends came here to listen and all that. We will be meeting quite often, as I told you. Once again, may not be at this scale, but at another scale. Thank you, one and all. Thank you so much.